form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Thank you. Please be seated. We are ready to hear argument in our first case, Cook versus the U.S. Mr. Cook.
Good afternoon, judges of the Fourth Circuit, and may it please the court. I want to first start by thanking the Fourth Circuit for allowing us to argue here in person today. I was terrified at the thought of having to argue this case virtually, but even more so terrified of not being able to argue at all. So thank you so much for allowing us to be here in person today. My name is Richard Cook, the plan trustee for Yahweh Center, Inc., and I'm the appellant in this case. In the 4 years prior to filing for bankruptcy protection in 2016, the Yahweh Center incurred over $300,000 in tax penalties because it failed to timely withhold, pay, and file its payroll taxes.
So have the underlying taxes been paid?
Some, not, there's still an outstanding claim to the IRS in the case of around $1 million as far as a priority.
That's unpaid withholding tax.
That's correct, Your Honor.
Okay.
Portion of it has been paid throughout the Chapter 11 plan confirmation process, but there still remains most of the priority claim of the IRS is still outstanding. So
the penalties that are the subject here are over and above the actual underlying tax.
Correct, Your Honor. And the penalties that we're referencing here also, we're kind of going back in time as far as looking at these penalties, because more so than avoiding the incurrence of the penalties, once those penalties are avoided, the occurrence of those penalties is avoided, then payment on those penalties would also be avoided. And that's primarily what this action is seeking to do, Your Honor, is to claw back the monies the Yahweh Center paid on these penalties in the 4 years prior to it filing for bankruptcy protection.
Well, before you, this kind of relates, I think, to what you just said, but while they're connected, you claim both the incurrence of the obligation and the payment are both avoidable. And is that correct?
Correct, Your Honor. And it's a two-step process. And I think,
let me just follow that. Maybe my questions will allow you to answer. And if not, I want to give you a full opportunity to. So please feel free at the end to say, hey, you didn't let me finish. I'm not trying to just avoid that. But looking at the North Carolina statute that the underlying claim, if you're allowed to proceed, would go under is I guess 3923.5?
Correct, Your Honor.
And if you are focusing just on the incurrence of the obligation, isn't the claim, the statute talks first about an obligation incurred by the debtor. That would be the tax penalty obligation, correct?
Correct, Your Honor.
And is voidable as to a creditor whose claim, and that claim would be the right to receive the tax penalties, right?
No, Your Honor, I think that it's avoidable as to a creditor whose claim, I think an existing creditor of the Yahweh Center.
The language is voidable as to a creditor whose claim arose before the obligation was incurred. So what's the claim?
So the claim is actually the claim held by the North Carolina Department of Revenue. And so the North
Carolina, for what?
For unpaid taxes to them as well.
Well, but you're not claiming, why would the claim not be the right to the penalty? It seems like maybe I'm missing it, but it seems to me taxes, the tax obligations are dealt with separately by the bankruptcy code and the law under it. And that's not voidable. So taxes and interest aren't voidable. And your claim, it would seem, and if your claim is the tax obligation, that's, we can go with that. But I think that gets you into some separate problems. I thought your claim was the claim to receive the penalty. It's not that?
I think the way to look at the the North Carolina avoidance statute, which we're using as applicable law here, it's the creditor itself. So when we talk about 544B1, there has to be a golden creditor who could utilize. So the golden creditor here would be the Department of Revenue, and that is who the creditor holding a claim under 39-23.5 is. It has to be an existing creditor of the debtor, because that's really the party withstanding to avoid the incurrence of the debt.
So is the claim of the North Carolina Department of Revenue one that in effect knocks the IRS obligation out of any priority receipt or knocks them into another class? What does the golden creditor get out of this?
So in this particular instance, Your Honor, the golden creditor would, one, avoid the incurrence of the obligation. So the tax penalties that were incurred in the 4 years prior to the bankruptcy case being filed, those would be nullified.
So what, does that increase the pot for payment to other creditors? Is that what you're trying to get at?
That's one point that we're trying to get at. The second point is, and there are courts, bankruptcy courts that have held to this, when you avoid the incurrence of an obligation, there's now no longer an antecedent debt for which payment was made on that obligation. So it's as if it doesn't exist. You know, avoid means to undo. It's a declaration. And so if there's no antecedent debt that you're making a payment on, then any payment that's being made was not for reasonably equivalent value. It was not reducing a debt that was owed.
The obligations of initiate.
I'm sorry, say that again, Your Honor.
You want to avoid the obligations from the very beginning, that they were void at the moment that they went on.
Correct, Your Honor.
So are you challenging all payments owed to the IRS pursuant to the bankruptcy plan?
No, Your Honor, just the penalty portions, because the IRS, and they filed a proof of claim.
Why aren't tax penalties seen as simply part of the overall tax debt owed by the debtor?
They're broken up separately. So the proof of claim that the Internal Revenue Service filed in the case actually breaks up kind of separate columns for what they're owed and why. There is a separate column for penalties, and tax penalties have been treated separately from the overall tax debt. This dates back to the Bankruptcy Act of 1898, where the old section 57J of the Bankruptcy Act of 1898 said non-compensatory penalty claims of a governmental unit could never have a claim in bankruptcy. They were barred from go. So penalties have been treated separately.
Does it differentiate in terms of the structure of creditor priority between IRS tax debt and IRS penalty debt?
Well, I would think so, because IRS priority debt is not avoidable, because IRS priority debt are the actual taxes and the interest. These absolutely provide value to a debtor. You know, this provides for the general welfare of the United States.
I didn't look in the code, but there's so many structures the code sets out with specificity. That's what I wanted to know, was whether or not the taxes are segregated out from the penalties in terms of priority of payment.
Yes, Your Honor. In the most specific place I can direct your attention is section 726 of the Bankruptcy Code. That is the priority of payment in a Chapter 7 case. And so, and this priority of payment in a Chapter 7 case actually has to be followed in Chapters 11, 12, and 13 of the code under something called the best interest of the creditors test. And so section 726A, give me a second, Your Honor, and I'll give you the subsection. It's 726A 4. And so in essence, you know, probably the very last claim to be paid in a bankruptcy case are claims for fines, penalties, exemplary and punitive damages. And so interest on claims and then money back to the debtor itself. And so this section of the Bankruptcy Code 726A was modeled, the legislative history of the Bankruptcy Code kind of pulls in section 57J of how tax penalties themselves in the U.S. Supreme Court in Simonson versus Granquist in 1962 was clear under section 57J. Tax penalties provide no value to a bankrupt debtor. In fact, all they do is punish the innocent creditors of the debtor. And so
I follow the logic of your argument, and having represented a number of bankruptcy trustees in earlier days, I understand the gradation of creditors and how that's been specified by Congress in the bankruptcy code. But notwithstanding all that, there doesn't appear to be any court that has considered this general issue that has agreed with your argument.
That's true, Your Honor. And I point out in the brief, there are some practical reasons why that is the case. First one is that it was not even clear until 2006 with the Katz bankruptcy decision that there was an express waiver of sovereign immunity as to the United States of America. So we didn't even know until 2006 that, yes, you can potentially bring this type of action. Similarly, the bankruptcy code itself, until 2006, you could only go back 1 year to avoid the incurrence of penalties or transfers. That was expanded to 2 years in 2006, but a Chapter 7 trustee is guided by the principle that they have to receive monies for the estate, not just themselves. And so in a case similar to this, where there have been years of litigation, it is entirely possible the trustee would incur a legal bill that would just prevent any distribution to the other creditors of the estate.
Is this a Chapter 7 bankruptcy or Chapter 11?
It's an 11, Your Honor.
Okay, well, that statute that you referred us to in the Bankruptcy Act a minute ago, 724A, and what it stands for is in connection with Chapter 7. What does that do to your argument?
Your Honor, so the priority of payout of Chapter 7 is incorporated to Chapter 11. It's what we call the best interest of the creditors test. If you give me a moment, it's section 1129A, 1129A7 of the code, 1129A7A. And essentially that an impaired creditor in a Chapter 11 plan will receive at least as much as they would get in a hypothetical 7. And so basically you have to figure out, well, what are the classes of creditors going to get in a hypothetical 7, and then ensure you're meeting that baseline with your Chapter 11 plan. So yes, 726, Chapter 7 is unique to 7, but that has been incorporated back into Chapter 11 with the best interest of the creditors test, Your Honor.
Counsel, could I just go back to the question I started with, and I'm sorry, the North Carolina statute. So are you saying the claim of the creditor, there just has to be a claim? It's not any particular claim. You're just saying if a creditor has a claim, any transfer or obligation would be subject to this statute?
That's correct, Your Honor. And so what it does is
I'm sorry, go ahead. You finish your answer, please.
Well, I guess what I was going to say, Your Honor, I think that the purpose of the statute being structured that way is if you owe money to someone else,
right,
at the time that you are insolvent, which is what this statute requires, and you make a transfer or incur an obligation that was not for reasonably equivalent value, well, that particular creditor that you owed money to who didn't receive the transfer, they were the one harmed here. And it is that creditor that has the standing to bring that cause of action under North Carolina law.
And it seems to me the penalty, the penalty is under the claim priority statute that you referenced, seems like a separate obligation. It's treated differently than interest, is treated different than the underlying obligation. And so that creditor isn't benefiting by the incurrence of another obligation. It's just another obligation. Now the payment's a separate issue, but the incurrence of the obligation, I'm just having trouble understanding how that, the policy or why that would matter at all. An obligation arises, it arises, and if it's valid on the date of filing, it's filing, and you got to deal with payments based on things like fraudulent conveyances and preferences and all those sort of things. But anyway, it seems to me if you're going to say the claim is just any claim, anyway, I just didn't, that didn't make the statute seem to make sense to me, but maybe that's just because it's new to me.
Briefly, Your Honor, I know I'm running out of time here. I think the policy perspective for that is what we kind of talked about for dilution, that if you incur a debt, I think an example would be, say, for example, a debtor incurred a promissory note for $100,000 and didn't receive anything for it. Like just the neighbor, we took on this fictitious debt.
Right.
If the debtor is already insolvent, which is what the statute tells us, if that debtor later goes into whether it's receivership or a bankruptcy, then like now this debt where it didn't provide anything, now it's going to share in this distribution as well. It's going to dilute the pot of assets when it didn't provide anything to the debtor for that.
Okay, it's diluted the pot for the payments that are made, that have already been made. But did I understand you say under the code, the unpaid penalties would come after unsecured creditors?
That's correct, Your Honor.
So it's you're trying to claw back the money's already paid. Okay, I got you. All right, well, you've got some time left on rebuttal.
Thank you, Your Honor.
Ms. Wolitzer, we'll be glad to hear from you.
Thank you, Your Honor. Good afternoon. May it please the court. I'm Rachel Wolitzer, representing the appellee of the United States. The trustee acknowledges that there are no cases in which tax penalties have been held to be voidable obligations under Bankruptcy Code Section 544B1. The Sixth Circuit in Southeast Waffles squarely held that tax penalties and penalty payments are not voidable under 544B1. The lower courts correctly held that under the...
I've read that case and they just sort of reached that conclusion. There's really no citation to the bankruptcy code for authority for their decision.
The Southeast Waffles decision was based on a number of factors. The court first looked at the fact that no other cases had held that pre-petition penalties could be avoided. So the lack of authority.
Well, that does get your attention as a judge.
Excuse me?
So that does get your attention as a judge.
Yes, there have been no cases that...
But
I'm sorry.
my question was more to, what's the bankruptcy code is so structured and it has so many exemptions in it from different types of claims like charitable contributions that are not avoidable, but you don't find penalties in any of those lists.
Well, there aren't any sections that say that penalties are voidable. So, and there are, as I said, there are a number of factors that Southeast Waffles relied on. So I think what you look at is the trustee cites 57J of the Bankruptcy Act, which is the predecessor to the current bankruptcy code. In 57J, penalties were not allowable. So it was a blanket rule not allowing all penalties. Now, when Congress enacted the bankruptcy code, it eliminated section 57J and its blanket disallowance of penalties. And as Southeast Waffles said, Congress specifically addressed the matter of non-compensatory penalties throughout the bankruptcy code, carefully differentiating the treatment of such penalties in different contexts. Despite the specificity included elsewhere in the current code, Congress included not one word about non-compensatory penalties in the code's fraudulent transfer provisions. And this holding was backed up by the Supreme Court's decisions in Noland and CF&I Fabricators, which held that a categorical reordering of the priorities set forth in the bankruptcy code is not permitted. So as the trustee pointed out, the penalties are afforded a lower priority in Chapter 7 cases. So that's a specific provision addressing the priority of the penalties. Although,
That's
I
the
think,
seven- go ahead.
I think his claim here is, it includes voiding the outstanding obligations that are not paid. But his goal is to get back the monies that were paid as a voidable transaction under section 544.
correct.
So that's, you might focus on that. And if I followed his logic correctly, if you assume that there is a waiver of sovereign immunity under section 106, then you're left with the question under this Uniform Voidable Transactions Act, whether or not it fits. And I could see the argument being made under that statute, the North Carolina version, there was an obligation incurred, the tax penalty, and the debtor did not receive a reasonably equivalent value in exchange for the transfer of the obligation. So at least on the face of it, it would appear that penalties would fit under that definition. So
Thank you, Your Honor.
why wouldn't they?
Okay. Actually, is it okay if, when I'm going through the language, if I address the question by Judge Quattlebaum about that
Sure.
claim arose before the transfer? Okay. So when you go through 3923.5, okay, and when you get to the language, whose claim arose before the transfer was made or the obligation was incurred, that language is simply addressed to the fact that this section applies to present creditors. And if you look at the heading of the section, it says transfer obligation voidable as to present creditors. So whose claim arose before the transfer was made or the obligation was incurred just basically says to the reader, this provision only applies to present creditors.
So you agree with the trustee's explanation that as long as you're a present creditor and have some claim, that part of it is satisfied?
Well, the hypothetical golden creditor, as he referred to the North Carolina Department of Revenue, would have a claim that arose before the transfer was made. The problem is penalties do not satisfy or do not really fit, as Southeast Waffle said, within the language if the debtor made the transfer or incurred the obligation without receiving a reasonably equivalent value in exchange for the transfer or obligation.
Well, but
So-
other than their ipsa dixit, I mean, why wouldn't it fit?
Okay,
It's an obligation, obviously, of the debtor, and they didn't get anything for it. You know, and this is, seemed like some of these cases may have gotten off the rails because we're all used to talking about fraud and constructive fraud in sort of common law terms. But here we're purely statutory under what the definitions of the bankruptcy code are and under the definitions of this Uniform Voidable Act. So it looks like to me, at least on the face of it, that it fits the language under 3923(5)(a). So I guess what I'm looking for is, why is that wrong?
okay, if you focus on the words in exchange for the transfer or obligation, that clearly denotes a transaction. So the constructive fraud provisions and the Voidable Transfer Act are aimed at transactions, commercial, contractual, voluntary transactions, because otherwise there's no exchange. And by logical extension, there's no reason why, if the trustee is correct that penalties fall within this, I mean the penalties fall within this, there's no reason why taxes wouldn't fall in this, because a debtor does not receive anything in exchange for paying taxes. The amount of a debtor's taxes is not determined by the value of services that the debtor receives. It's not an exchange. It's a statutory obligation.
Well, he
And it-
says what I think the argument on that is, yeah, now whether it's a reasonable equivalent value may be a point there, but there's value that all that receive as part of the general welfare, the social contract that we see. I mean, yeah, what about that? We can debate maybe the dollar for dollar aspect of it, but there's benefit that taxes provide to everybody.
There's no distinction in the Internal Revenue Code between taxes and penalties. There are specific statutory provisions cited in our brief that say penalties are treated as taxes. The money all goes into the same pot, and all of that money goes to infrastructure and services.
But taxes and penalties are distinguished in the bankruptcy code.
Yes, in terms of priority. So penalties are given a lower priority than the tax, but that doesn't mean that they can be voided. And the very fact that they are given priority and that there are so many provisions in the code that deal with penalties, well, if they were just going to be voided anyway, then why does the code need to deal with them? As the Supreme Court said in Noland and CF&I, you can't just take all those provisions in the bankruptcy code that deal with the priority of penalties and say, oh, well, we're not going to look at those. We're going to make a blanket rule that penalties are voidable. So that's inconsistent with the Supreme Court law on that. And again, it's not an exchange. So you don't pay your taxes in exchange for a certain amount of services. So how can you say it's a reasonably equivalent value? So biological extension, the trustee's argument would result in the voiding of the taxes as well as the penalties. So just getting back to some of the other points covered. Again, this is a Chapter 11 case, not a Chapter 7 case. So unless the trustee is expressly invoking 724 or 726, which he isn't, those sections do not apply.
Well, he said the best interest of the creditor causes it, that 726A4 to be incorporated into Chapter 11, even though it's not a Chapter 11 section. What's your
Yes,
response
but
to that?
again, thank you, Your Honor. Again, that's a priority provision. So it's not calling for the penalties to be voided. It's just saying they have a lower priority. That's the basic difference between the Bankruptcy Act and Section 57J, and then the Bankruptcy Code, which was enacted in 1978, which got rid of 57J, and instead of a blanket rule against penalties, allowed penalties in certain circumstances and said what the priorities were. The trustee's citation of CATS to support why there are no cases on this issue, that there are practical reasons why trustees haven't wanted to go after these penalties. Well, first of all, the CATS case doesn't apply at all because it was decided, it was a decision regarding states' sovereign immunity. It was not a decision regarding federal immunity. And the court specifically held that the state's sovereign immunity was limited. Plus, that decision was decided in 2006. So it's been some time since that decision was decided. Again, I'd like to go back to some of the other parts of the Southeast Waffles rationale. Again, if you even look at the Voidable Transfer Act, section 39-23.65, there's a definition of when an obligation is incurred. And it says, an obligation is incurred if oral, when it becomes effective between the parties, or B, if evidenced by record, when the record signed by the obligor is delivered to or for the benefit of the obligee. Well, here, the penalty is not an oral obligation, so we look at B, but the penalty is not evidenced by a record signed by the debtor as obligee. Therefore, the debtor did not incur the obligation and did not incur the obligation for less than reasonably equivalent value. So this definition of when an obligation is incurred, again, clarifies the contractual nature of the exchange contemplated by the Voidable Transfer Act. Again, Southeast Waffles also relied, as the lower courts in that case, on what the trustee claims is an overstated concern for the Pandora's box of litigation that could result from allowing the voiding of penalties. First of all, this would apply to all kinds of penalties, not just tax penalties. And the concern is also addressed to the proliferation of litigation that would result from trustees and debtors trying to avoid penalties. One of the purposes of bankruptcy is an orderly and efficient administration of the estate. And if there are, every time there are penalties of any kind, and that would cause debtors and trustees to try to avoid them, that would really increase the litigation that bankruptcy courts have to deal with.
But there's, but there are a lot of policies the bankruptcy code addresses. That it addresses the equal distribution of equal distribution to the creditors. It effectuates fresh starts. I mean, it's hard to pick out one policy and say that drives, because it seems to kind of agree that the claim is just the existence of a present creditor. And if that's the case, your argument, hinges on us, if we're going, hinges on the fact that you can kind of imply through the act that there's this voluntary exchange requirement, as opposed to that the tax is just being different. And I've read the briefs and read it, and I get the point. That's on the other side of that, it'd been pretty easy to exclude, to make that clear in the bankruptcy code. So we're kind of reading tea leaves a little bit on the one hand, when it's not that clear from the actual text.
I just think it was never even contemplated that anyone would try to avoid these penalties, as is shown by the fact that there's no case law on it.
Yeah. Maybe.
So it just doesn't, as the Southeast Waffle Court said, it doesn't fit. This provision, again, it's not reading into it the language that requires an exchange, which is clearly a contractual concept. So there has to be an exchange for reasonably equivalent value. So, okay, penalties.
You would have thought, though, that in a rational world, which we're dealing with Congress, when they took 57J out, there would be some legislative history statement that said this continues over in another section, or we're taking this out to treat penalties differently. There isn't anything. So you're left to guess as to what the congressional intent was.
Well, again, you look at the entirety of the bankruptcy code and all the different provisions that address penalties. So as examples of some of these, 503B1C allows post-petition tax penalties as an administrative expense. Section 505 provides for the determination of the amount or legality of any tax or tax penalty. 523A7 provides that tax penalties are non-dischargeable if the underlying tax is non-dischargeable. And Section 724A provides that the trustee may avoid a lien securing a penalty claim in a Chapter 7. And as the trustee mentioned, 726A4 gives fourth priority for non-compensatory penalties in Chapter 7.
So is your point that if the trustee's right, tax penalties would always be voidable, taking his argument to the conclusion? And then why would he have all these provisions that deal with tax penalties as part of the estate? Is that your argument?
Yes, exactly. Because again, the Supreme Court in Nolan and CF&I Fabricators held that a categorical reordering of the priorities set forth in the bankruptcy code is not permitted. So 57J disallowed all penalties. The bankruptcy code does not. It has specific provisions that address the penalties. And so, and also, by the way, the Simonson and Elliott cases were both decided under 57J. And those cases are cited by the trustee. So if there are, I see my time is up. If there are no further questions.
Thank you very much. Mr. Cook, you've got some rebuttal time.
Thank you, Your Honor. Wanted to address a point that you had brought up as far as legislative history, Judge Agee. There actually is legislative history with regards to 57J when the Bankruptcy Act switched over to the Bankruptcy Code. The statement in the legislative history, and I'm just going to read verbatim here, it says, the subsection follows the policy found in 57J of the Bankruptcy Act of protecting unsecured creditors from the debtor's wrongdoing, but expands the protection afforded. And this is actually in relation to the new 724A of the Bankruptcy Code. And so it was adopted as part of the Bankruptcy Code, this protection from 57J, and it was expanded in that tax liens that include penalties, a 7 trustee can automatically avoid those and preserve it for the benefit of an estate. And so,
well, if the tax penalties are void or voidable under your theory through 544, why did Congress include all these ordering provisions for penalties elsewhere?
Your Honor, I think it's more of a limited basis when if the reasoning of the trustee is followed here, we're still limited to certain situations when this can happen. We're still, one, looking at generally a 4-year look back period, which is based on state law. I think there's a couple of states that include 6 years. So it's still, one, you can only go back so far. The second thing requires the debtor would have to have been insolvent at that time. So you're going to have evidence that the debtor was insolvent at the time that the obligation was incurred. So that's another requirement. Additionally, you're going to have to show that there was a creditor that was owed at the time that the debt was incurred. So there's still a lot of evidence that is still going to need to be put forth in limiting circumstances to where this isn't just going to be a broad brush open season of avoidance here. But and I get that, I understand those points. There are factors, but the proposition of no value received would apply across the board. You might have for a penalty, right? I think for a tax penalty, yes.
Okay.
And I think tax penalties are unique here in that, so Section 505 of the code is very unique and it's just for taxes. It actually allows a bankruptcy court to basically sit as a tax court, that a bankruptcy court can basically go back in time and determine the propriety of any tax or penalty, whether it's been paid or not, whether it's been assessed or not. And so I think that it's unique to the issue of tax penalties because, we have 57J, we have Simonson versus Granquist from 1962 that understands tax penalties don't provide value. Section 505 of the code, again,
say it's a penalty from the EPA or a state water control board or the Securities Exchange Commission. Wouldn't your theory be equally applicable to those?
If it is a non-compensatory penalty, that's correct. I think it would. Now, it's possible. Now, the bankruptcy code recognizes under 507A8G that compensatory penalties actually have a higher priority under the bankruptcy code. So there still has to be a determination of, is it a non-compensatory penalty? Is it a compensatory penalty? And so I think it's a little bit of a hyperbole to say that this is going to be a Pandora's box, because it assumes Congress didn't intend for this, but Congress intentionally waived sovereign immunity as to these types of causes of action.
Would there, what about contractual fees or penalties? Would your argument apply to that?
Correct. And that was actually something that was done in this particular case as well.
So if you have a lease that says you pay X amount a month and you don't pay and a penalty is assessed to it, even though that's part of the contract, or a mortgage that says that there's interest, and if it were to contractually say you have a fee if you don't pay the amount, you're saying that that would be no value either, no reasonable equivalent value either?
I do, but for different reasons. So situations like that, North Carolina is a good example. North Carolina, going back common law over 100 years, does not enforce contractual penalties. Now, liquidated damages, it will, but just a pure penalty, it won't. It won't compensate. And that actually dates back, and I included it in the brief. This goes back to English common law of the 17th century, that contractual penalties are just not enforceable anyway. And so that's more of a common law concept. And so I don't think this is now going to mean, these additional penalties are going to be avoided here. I think parties were able to do that anyway. But in this particular case, there were some penalties that were assessed by SunTrust Bank, and ended up having to go up on appeal before the district court. The district court actually reversed in my favor, and we settled it. But yes, that has been used or could be used, and it actually has been done in this particular case. I want to address a couple points from the Southeast Waffles case. One, the court was clear in Southeast Waffles, there was no fraudulent obligation cause of action in front of it. In this case, it is in the complaint, because you have to, one, avoid the incurrence of the obligation before you can then recover and avoid any of the payments made on the obligation. So the court in Southeast Waffles was crystal clear that this debtor had not pled a cause of action to avoid the incurrence of the obligation, which all these avoidance statutes state you can avoid an obligation or transfer. It didn't do that. I also want to point out that it makes a big deal about where they're an involuntary creditor, the IRS. They're just doing their job assessing these penalties. Well, voluntary and involuntary is kind of a big deal in bankruptcy. Like, the code will define whether it's a voluntary or involuntary transfer. There are sections of the code 522 where an actual bankruptcy, an individual bankruptcy debtor can undo transfers that a trustee could do if it was an involuntary transfer. You look at section 301 of the code, talks about voluntary bankruptcy filings. You look a couple sections later, involuntary bankruptcy filings. And so there is a distinction between involuntary and voluntary that the bankruptcy code makes statutorily. And so that is intentional. You don't see voluntary and involuntary in 544B1 or the North Carolina Avoidable Transactions Act. Additionally, it makes a point to say, well, these were legitimate debts. They were legally incurred. Well, that was actually written out of the Bankruptcy Act. The Bankruptcy Act, the older version, 70E, this golden creditor statute, said debts that were legally incurred could not be avoided. Well, that was written out in the new section 544B1. There is no, if it was legal when incurred, it is valid. And so if there are no more questions,
We're good.
would just ask that the opinions below be reversed. Thank you, Judge.
All right. Thank you very much. Our normal court practice is to come down and greet counsel in person. COVID is preventing us from doing that. So we thank you for your arguments, and would ask that you clear your tables and let the next folks know that we're ready for them. And those of us on the bench are going to stand and take a stretch break in place. Counsel, thank you again, and you'll bring in the next group. Thanks, Emma. Please be seated. So we're ready to hear argument in our next case, Wilson versus United Healthcare. Ms. Luzery,
Yes, Your Honor.
when you're ready,
Yes, Your Honor.
have at it.
All right. Good afternoon, Your Honors. May it please the court. ERISA is a statutory scheme enacted by Congress, and the purpose of ERISA is to protect employees and employee welfare benefit plans. One of the ways ERISA does that is by guaranteeing a meaningful dialogue between administrators and claimants, of which includes the good faith exchange of information. That did not happen in this case, and my argument is going to focus on two main ways that the district court erred. First, in determining that Wilson's January 26, 2017 letter was not an appeal, and second, that United Healthcare was not required to respond to Wilson's request for documents. Now, in determining that Wilson's January 2017 letter was not an appeal, the district court misinterpreted one of the plan terms, and the plan term speaks of a retrospective review. So the district court found that what Wilson was requesting was not an appeal, but rather a less formal retrospective review. The plan document does outline what a retrospective review is. However, the retrospective review is something that United Healthcare undertakes, not a claimant. The retrospective review is part of a utilization review process, which is the process that United Healthcare undergoes to determine a claimant's eligibility for benefits.
Counsel, does your first argument, I understand the argument about the utilization review and appreciate that from the briefs. Does it matter whether or not the attorney letters were appeals if you may?
Your Honor, under the doctrine of futility, Wilson would be excused from further exhausting administrative remedies, even if it's determined that that
Include the notice of appeal.
Yes, Your Honor. Even if it's determined that the January 26, 2017 was not an appeal letter, which it's our position that it was, at minimum, it was a request for documents that was not fulfilled despite two valid documents. So even if that's determined not to be a formal appeal letter, again, it is at a minimum a request for documents that was not responded to. Again, the Code of Federal Regulations does not say that a request for documents must be accompanied by a formal, even if they do not lodge a formal appeal.
And just because you requested documents in the letter does not make it not an appeal.
Correct. So it's our position that the January 26th letter was essentially a part and parcel letter. It was requesting an appeal and then also requesting a copy of each and every document upon which the denial was based, so that Wilson would have a reasonable opportunity to review those documents, determine what needed to be responded to, and prepare substantive materials to respond to that.
So, does the record tell us whether the treatment for the third date of service, which you contend to be dates before the attorney letters and after the attorney letters, does the record tell us whether those claims have all been denied or not?
Not in the record, no, Your Honor.
I mean, have they?
I would assume so, yes, Your Honor.
Well, okay. No, I mean, I shouldn't have even done that once I said they're out in the record. But tell me why you assume that, since I kind of went off the reservation a little bit.
All of the dates of service up to that point were denied based on a lack of medical necessity. And I believe that United Healthcare argues in their brief that the third date of service, which is everything from the date of those EOBs through the date of discharge, have been denied. However, that information is just not contained in the record. Along with the request for documents, Your Honors, again, the Code of Federal Regulations does not parse out, unlike where the district court ruled, it does not parse out that a formal appeal request must accompany a request for documents. The request for documents stands alone. If the district court's opinion is allowed to stand, unfortunately, it's going to cause widespread negative effects to claimants in various ERISA cases. It's going to send the signal that administrators can simply ignore a claimant and have no repercussions for their actions. And this is completely inconsistent with the statute, the Code of Federal Regulations, and prevailing case law in this circuit. And it's going to send the message to claimants that there's no purpose in appealing because they're going to simply be ignored. And unfortunately, that is completely contrary to the spirit of ERISA, which is to protect employees and provide a meaningful dialogue between administrators and their claimants. So we would respectfully ask that the district court's opinion be reversed and either remanded to the district court with instructions to remand to United Healthcare, or to certainly within this court's power to directly remand it for consideration. Do Your Honors have any additional questions?
Well, you've got some rebuttal time, so now we'll hear from Mr. Kimball.
Thank you so much.
Good afternoon, Your Honors. I'm Chris Kimball. I represent United. This is my first time to argue in the Fourth Circuit. And after a long career, it's about time. I'm honored to be here today for arguing with you. So I want to start off with the HIPAA issue, because that really is the linchpin and the explanation for why things happened the way they did. I don't believe now that there's any dispute that the HIPAA authorization that Wilson's counsel submitted to United was invalid. That does not seem to be disputed. The dispute appears to be what was United supposed to do when presented with an invalid HIPAA authorization.
Well, maybe tell the claimant that it was an invalid HIPAA authorization and you needed something more.
And if you could do that without violating HIPAA, I would agree with you.
Well, was everything that was being requested covered by HIPAA?
I think there needs to be a distinction between what HIPAA protects and precludes, and don't confuse ERISA documents with information under HIPAA. HIPAA prohibits the unauthorized dissemination of protected health information. It doesn't speak to specific documents.
Right, so I was asking, does everything that the claimant requested fall under HIPAA?
They would have to have a valid HIPAA authorization for United to provide any of them.
Well, the request letter covers documents, which include any medical documents. Let's take that in a moment. but substantive documents, the plan documents, and any internal guidelines or regulations. So how could HIPAA apply to those?
Because the existence of coverage for a particular individual is itself protected health information under HIPAA.
So
If
you're
United-
saying the plan document is a HIPAA protected document?
I'm saying that United providing that plan document in reference to a request regarding this particular patient would be providing protected health information, telling anyone that X individual has coverage is the provision of protected health information. Had we done, and it could have been a medical record, it could have been a plan document, it doesn't matter if it's a plan, but the law is clear that if you disclose that insurance coverage and documents related to insurance coverage are protected health information. If we had disclosed that to Wilson's counsel without a valid HIPAA authorization, it would constitute a violation of HIPAA.
Then I go back to my question, why not tell the claimant that there's a problem with the documentation you submitted with the signature here? We need that corrected.
There's a couple reasons for that. And I understand that makes all the common sense in the world. It makes common sense that we would let counsel know, hey, look, there's a problem with your authorization. You need to fix it. The problem is, even doing that would constitute providing protected health information. There's no common sense exception.
How does that work? That doesn't make any sense to me.
I agree with you. I absolutely agree with you, but there's no common sense exception to
Okay, the
HIPAA.
question
It's a
was,
strict
how
liability.
does that, why? Where do we look to see that you can't tell somebody your signature on this HIPAA authorization is on the wrong line or signed by the wrong person?
Because it would involve providing protected health information without a release.
Well, no, if you wrote back to the council and says, we've received these items from you, there's a document that purports to be a HIPAA release, and we're unable to determine the terms of the release and who the signatories are, period, very truly yours. How is that a HIPAA violation?
I will tell you why. Let's assume that letter was sent to Cigna instead of United Healthcare. Cigna doesn't insure this particular individual. Cigna gets that letter. Do you really think that they're going to send a letter to Wilson's counsel saying, you sent me a valid HIPAA authorization, an invalid HIPAA authorization, send me a valid one, and I'll tell you, this person is not covered by us. They're not going to do that. They're going to respond, if they respond at all, they're going to respond by saying, we never heard of this person. And they have no obligation under HIPAA to that individual because they're not a covered entity
Opposing
as to that
counsel is
individual.
right when she says that if the district court opinion is allowed to stand, that it's going to send a message that administrators can just ignore claimants with no repercussions. I guess what you're saying is administrators can currently just ignore claimants.
Well, to do what you're doing, they would have to incur the potential penalties of a civil and criminal violation of HIPAA to get to that point. The problem with that is there's no duty apart from HIPAA. Let's just say this, apart from HIPAA, there's no duty on behalf of any ERISA fiduciary. I'm talking about where a representative, let me step back a second. ERISA contemplates representatives acting on behalf of beneficiaries. And fiduciaries are obligated to work with representatives on behalf of beneficiaries. They are not allowed without a valid HIPAA authorization to provide any protected health information.
What was the
So
problem with the HIPAA authorization here?
it had an invalid signature. It's one of the 6 core elements of a HIPAA
Because it
authorization.
was on the wrong line, or because it appeared to be the minor signature, or both?
You have to look at the document as a whole. The document purported to be an authorization by the patient, had his social security number on it, had his name at the top of it, had a signature line for the patient. And it specifically said, I am providing this authorization on my own. He was legally incapable of signing that.
So it was because the minor's signature was on it and not the custodial parent's signature.
That's correct. There's a separate place. If you look at that form,
So
you'll see
what
there's a,
HIPAA violation is it to respond back and say a minor can't sign this legal document?
Because it's an implicit admission that there's coverage, and that's PHI. Why else would United do that if they didn't have something to tell them once they got a valid authorization?
Well,
If
you
they
have
didn't,
something to tell them one way or the other, even if the Cigna person, if it's not coverage.
the Cigna would have no obligation to respond to them, but if they did, that's probably what they would say. They wouldn't go to the administrative expense of getting a different authorization in order to say, not our person.
So counsel, your interpretation of there being a HIPAA violation based on the questions we've all kind of asked, has a court recognized that as a violation? Can you, other than your interpretation that would be an implicit admission of coverage and therefore a violation, is there any court that's ever adopted that interpretation?
I've not found one on these facts. I did cite the Tate case to you, which is the closest we could find,
Right.
which is when an authorization was required in that particular case, and that acknowledging, and that's the important point for us in that case, was acknowledging that you even had new records on that person in response to that document that was submitted to that insurer would constitute a violation without an authorization. And that's our case. We don't have a valid HIPAA authorization. And that's the thing is that gets me about this particular issue is Wilson's counsel had two different opportunities to fix that problem.
Of course, they didn't know what the problem was.
Well, I believe they did. And let me tell you what. When in my practice, when I've sent something out that should have generated a response from someone, and I don't get a response, the first thing I do is to look to see what I sent out, because I want to make sure, first off, it actually went out in the mail, and second, that I dotted all the I's and crossed the T's, and frankly, because I don't want egg on my face. But if it's there, then that's when I look to say, you should have responded to me. I don't assume out of the box that I was being ignored. So a month later, Wilson's counsel sends that same letter again and says, I sent you this letter last month. And she talks about the medical records that she had that she was going to get any day now. She didn't include those, never did send those. But she does include the first letter, and she does not attach the HIPAA authorization, though, to that second letter. That would have been a second opportunity. Anybody, as much time as they spend in this space, they could have looked at that and said, it'd be obvious to anybody looking at it, that signature is on the wrong line and it's invalid.
Well,
And there's
other than the Tate case that you referenced us, is in your briefing or somewhere in the record before the district court, have you given any more specific HIPAA statute, regulatory, or case law that would be relevant directly to this particular situation?
in what way? There are several issues on that. You're talking about as to whether we have an obligation to query the council if that's what they are if that's what
That and what your authority is not to query council.
Okay, my authority not to query council is under ERISA. There's no obligation under ERISA
Wait, do you
to
have
contact.
a site, a statute, a regulation, a number of?
I can give you a case.
Something,
I
is
can
it
give you-
Tate again?
Yes, Your Honor, I can. And I'll give you the case. It's Ellis versus MetLife out of the Fourth Circuit, which said that ERISA does not impose a duty on fiduciaries to help claimants prepare, perfect, or prevail on claims. It's no different than appeals. Appeals are not any different than that. And the reason that the Fourth Circuit said that was the law is because our duties, the fiduciary's duties, run to the plan as a whole. They don't run to any particular claim.
Ellis versus what?
MetLife?
Yes, ma'am. 126,
Is that in
Fed Third, 228.
Where is that in your brief somewhere?
I think it's in plaintiff's brief, actually,
All right. So it's not in yours.
not in mine.
So
For
we,
the position that you're espousing, it's not in your brief.
The position that we had a duty, I'm sorry.
I don't know, I thought you just cited Ellis versus MetLife as support for your argument.
That's correct. Yes, sir.
Okay. In your,
asked me about just now is where's the source of the duty
right?
that says you have no obligation to do that? And you have, and this court has said,
But
under
you
these
have a-
circumstances, that obligation does not exist.
But it's fair to, I mean, I understand the general proposition. You don't have a responsibility to do their work for them, perhaps. But when they submit a request that the plan authorizes them to make and that obligates you to respond to generally, and that ERISA authorizes them to make, and that ERISA obligates you to respond to generally. We're not talking about making a claim. We're talking about responding to a claim that you have an obligation, both plan-wise and by statute, to respond to. And it sounds like you're saying, yeah, you don't have to, because doing so implicitly suggests there may be coverage as it and is a HIPAA violation.
That is correct.
Okay.
That's
All right.
my
I
position.
think at least I understand the argument, and we'll decide whether it's, if that's wrong.
That's the Tate case in your.
Tate supports my position on that. I cannot find a case directly on point that's on all fours.
Well, I don't,
So
I
Tate-
cut off
Go
Judge
ahead, go ahead.
Quattlebaum, but I think it would be useful to us for there to be a 28J letter with specificity citing to HIPAA or its regulations or specific cases as to why the non-medical documents could not have been disclosed. And then opposing counsel can answer the 28J letter if she so chooses. Well, I don't want to take up all your time with this part, but if I could suggest that if we just assume for purposes of argument that we disagree with your HIPAA position, why don't you take us through the rest of the case from your standpoint?
So if you disagree that we had an obligation to conduct the appeal or an obligation to provide documents.
Let's start with providing the documents. That we conclude that there was an obligation to provide documents.
All right, sir. If that's the case, then the correct remedy is obviously not that plaintiff wins benefits. The Gagliano case out of this circuit makes that clear. It would be to provide the documents and then do a double remand back to United Healthcare to conduct the appeals. I think it's hard, though, to divorce the document request from the letter. And that seems to be what the court's focusing on. There was a document request in it, but also it was a demand that we provide or initiate an appeal. And you have to consider the context in which United is considering this when it gets this letter. There's a 30-day deadline in which to conduct an appeal in this plan document. There is also a provision in that plan document that tells individuals, if participants, if you need assistance with your appeal, you contact an entity that's established by the state of New York to provide you assistance in an appeal. So the reason that United could not respond either to the appeal, actually it's twofold, they can't respond to the appeal. First off, there's no valid HIPAA authorization. Second, counsel does not dictate how and when a appeal is conducted. The plan is talismanic there. It says you have to do it within 30 days. So United couldn't even do what plaintiff's counsel asked them to do by starting an appeal, then put it on hold at her discretion when she got in the rest of her points. And she makes that point. If you look at the letter she sent and you look at what the plan required to be submitted, even though she took issue with the fact I don't have the plan, all of the elements required in the plan that's supposed to be in an appeal letter, she touched on in her letter. I don't know if she actually had the plan or not. Perhaps she got it from her client. I don't know. I know she didn't get it from us because we didn't have an authorization to give it to her. But the point is, there was no prejudice to her or to Wilson for not having all of those documents in order to make the appeal that they wanted to make. They just didn't have their information together yet. And they had 180 days from a denial in which to pull that together.
But aren't you making that decision on council's behalf?
I'm sorry. sir, I
Aren't you
couldn't
making that decision on council's behalf, opposing council's behalf?
By doing what?
Well, by saying that they didn't need a number of the documents that were non-medical related that they requested.
No, I'm not saying that at all. They're entitled to get them from us if they have a valid HIPAA authorization.
All right, let me ask you separately, the district court, as part of its decision, is that the first letter of review, but looking at the terms of the plan, by definition, the retrospective review is for a medical service that was rendered without prior authorization. And it's reviewed after the fact to determine whether or not there'll be a payment made for that, assuming usually to the provider. So that wouldn't have anything to do with an internal review for appeal. I mean, that just seems like to me that the district court was wrong under the terms of the plan when it made that determination.
I agree with you. It got confused. The retrospective review, you're exactly right, refers to services that have already been rendered. It could be an initial denial is a retrospective review. It could be an appeal of an initial denial. It could be a retrospective review. However, the significance here is that that's harmless error because the district court got it right that the letters were not appeals because it didn't contain all of the elements required by the plan for it to be an appeal.
So why does that, if you're correct there, that that the letters are not sufficient to be an appeal, why does, aside from HIPAA, why do you not have to produce the documents? Is there something that says you don't have to produce documents before there's a valid appeal letter? So you got an appeal letter. I mean, you got a letter that, as you said, under your argument, is not an appeal letter, but is a mere request for documents. And you seem to say you don't have to have appeal letter in order to obligate you to produce the documents.
That's correct.
So what is, does that get us back to HIPAA? That's the only thing
That's the only reason.
Okay.
We didn't get the documents is because there was an invalid HIPAA authorization attached to the letter.
Okay.
Anything else you want to tell us here in your closing seconds?
In my 2 seconds, no, sir. The opportunity.
Thank you very much. Ms. Luziri, you've got some rebuttal time.
Thank you, Your Honor. Just a few points. The district court found that the plan document is not governed by HIPAA, and the district court is correct on that. The owner of the plan, if you will, or the claimant, is not the minor. It's Kenneth Wilson, who is my client. It's not contained in the joint appendix before this court, but with the lower court administrative record, I also included with that January 26th letter a confirmation of representation giving United Healthcare the right to correspond with me on this claim, which is a right that is guaranteed under the regulation. Your Honors, I have.
Where do we find that now?
It's 29 CFR. I know I cited it in my brief.
No, the actual letter.
Oh, I'm sorry. The confirmation of representation is included in the lower court's administrative record. I can provide that to the court.
Now, why don't you do your own 28J letter and send that to us and tell us where we can find it?
Yes, Your Honor. The plan document, again, is not governed by HIPAA. It's clearly governed by ERISA. The regulation contemplates that that should be provided. Technically, I could have written to Wilson's employer and gotten the plan document with no problem. Administrators have the duty to provide those documents. At the bare minimum, they should have provided me the plan document. United Healthcare is arguing that my appeal letter didn't comply with the terms of the plan, while at the same time saying that they were not required to provide me with the plan. And so I can't abide by something that I'm not provided. Second, I would respectfully submit that the Ellis decision actually supports my position. It was one of the first cases that this court came out with back.
Which is why you cited it 4 times in your brief.
Yes, Your Honor.
It's also in your attorney letter in January of 17, right?
Yes, Your Honor. It's my understanding that this was if not the first, one of the first cases by this circuit that interpreted the Code of Federal Regulations to require that the claimant's opportunity to review each and every document upon which the denial is based is absolutely essential to a full and fair review. This court followed that up with Gagliano, which I believe was in 2008. And most recently, while not cited in my brief, the Odell versus UMWA case, which is an unpublished decision from 2019 from this court, also says that if you are using a document to deny a claim, then you have to provide that to the claimant and give them the opportunity to respond to that. Back to the HIPAA argument, Your Honors, I have several cases where an insurance company wants their own authorization signed. They send it to me. I send it to my client. We get it filled out. We submit it. I have no other problems. I cannot know that a HIPAA compliant release is signed on the wrong line or somehow deficient if they're not going to tell me. I can't respond to something that I'm not given the chance to respond to. I believe I cited in my briefs as well. The joint appendix is clear that they received my letter. They marked it as an attorney request for documents, and that's it. They never told me the HIPAA compliant release was wrong. They never called me. They never emailed me. They never sent me a letter. I cannot correct something that I'm not aware of as an error. And so for those reasons, we would, again, respectfully request that either this court remand it back to the district court to remand it back to United Healthcare or remand it back directly so that we can exhaust administrative remedies.
Well, thank you very much. It's part of our traditional court practice to come down after every argument and greet counsel in person, but that's a casualty of COVID, at least for the time being. So we will thank counsel for your arguments today and look forward to receiving your 28J letters and any response to those, keeping in mind they are not supplemental briefs, they're letters. And with that, I'm going to ask the clerk if she'll declare a short recess, and the court will go out and take that and then come in for our last case.
This honorable court will take a brief The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
Thank you. Please be seated. And we're ready for our next case, U.S. versus Sitton. Ms. Albro.
Yes, Your Honor. May it please the court, this is Kimberly Albro here on behalf of the appellant Dominicus Sitton. This appeal involves a very narrow slice of convictions which Mr. Sitton submits do not meet the definition of felony conviction under U.S. Sentencing Guideline 2K2.1. The only prior convictions that would be implicated by your decision in this case are South Carolina Youthful Offender Act convictions, which were committed when the defendant was not yet 18 years old. Mr. Sitton submits that under the plain language of 2K2.1 and the relevant cases in South Carolina interpreting the Youthful Offender Act, a YOA conviction is not classified as an adult conviction by South Carolina. And the guideline 2K2.1 requires that if the conviction is to qualify as a felony conviction, it must be an adult conviction. And that is, what is included in that is a conviction where the person was 18 years old when they committed the offense. If the person is not 18 years old, then the guideline requires that the state classify it as an adult conviction.
Why isn't, in South Carolina, I think, if you're 17 or under, the family court has jurisdiction exclusively, and there's a process by which a case can be transferred from family court to general sessions court. I think the code, y'all probably know it better than me, but the code has those provisions, and I think the family courts apply the U.S. versus Kent factors, and if they transfer it and the court in its discretion has decided that it goes to general sessions, why isn't that process an expression that it's an adult conviction?
Well, I looked extensively into general sessions and whether it's defined as an adult court solely, and I couldn't find anything that shows that. My understanding, although I'll be upfront, I've never practiced in South Carolina State Court, but I've looked as well as I can and consulted with people who have. That process that you described is correct, that the family court can move for the juvenile to be tried in general sessions court, but I don't think being in general sessions court alone meets the definition of the guidelines, which that it is classified as an adult conviction. And the example given in the guidelines is that the person who is under 18 is expressly preceded against.
Does South Carolina's two strikes law require adult convictions?
I am not sure. I believe so, but I really couldn't say.
Well, it seems that because the South Carolina case State versus Standard held that a youthful offender conviction in the Court of General Sessions sentenced pursuant to the Youthful Offender Act was a predicate conviction for purposes of South Carolina's two strikes law. So if that's the case and the two strikes law requires adult conviction, then South Carolina, at least in this case, seems to say that general sessions convictions are adult convictions.
And I really couldn't speak to, I mean, I'm happy to look into it or provide further briefing, but I really couldn't speak to the two strikes law in South Carolina. I do know that
Is the converse true to the extent that if someone who's not a legal adult is convicted in the general sessions court, that cannot be a juvenile conviction? I guess they aren't termed convictions for juveniles.
they're juvenile adjudications or adult convictions is my understanding. And the reason the youthful offender.
Well, I mean, is there any South Carolina case that says that the juvenile who's tried in the general sessions court is not guilty of an adult offense?
Not that I'm aware of. I don't know that there has been the cases that I found that were relevant in defining whether Youthful Offender Act was a juvenile adjudication or was an adult conviction seem to suggest it's somewhere in between. It's some kind of hybrid. So Mr. Sitton isn't submitting that he had a juvenile adjudication. What he's submitting is that for some purposes, and again, like Judge Thacker brought up, the Two Strikes Act, I'm not sure how that's treated under state law, but the Gay case, the Gay versus Ariel case, which I cited in the supplemental briefing, does treat these adjudications differently for purposes of expungement than it does.
That's as I understand that case, it's saying that if you are within the age period covered by the Youthful Offender Act, most of which are for people who are adults, you can take advantage of the Youthful Offender Act expungement provision. In other words, it's not limited to that 17-year-old person who's covered by the act. It seems to me all Gay is saying is that if you are between 17 and 25, you get the benefit of the expungement provision, not just if you're only 17. And so I don't see how that, I don't see how that establishes that if you are under 17, you're not being tried as an adult. It looks like when you're transferred, you lose the confidentiality that exists for provisions carried out by the family court. You're obviously subject, to all the other aspects of General Sessions Court. I guess I'm having a hard time seeing why that's not effectively, if not explicitly, an expression that it's an adult conviction.
Well, on the flip side of that, I would say, and I think this is why it is considered hybrid. I mean, there's the Kraft versus State case, which goes all the way back to 1984, where the court said they're neither juvenile nor adult convictions. So if the court wanted to engage in a case-by-case analysis of these youthful offender convictions that occurred when a defendant was 17 or younger, there are also aspects of it, especially if the sentencing judge chooses to apply other parts of the Youthful Offender Act sentencing portions that make it more like a juvenile adjudication, such that they're offered treatment, they have an indeterminate sentence of up to 6 years, and that applies even if the person could have, under the adult statute of conviction, for the offense, even if they could receive a sentence that was less than 6 years, that the statutory maximum is less than 6 years, if they're convicted as a youthful offender because the court believes they could benefit from treatment because they're a youth, it doesn't matter that the other sentence under the statute of conviction as an adult could be less. So there are aspects.
That also, under that sentencing scheme, that can also apply to individuals 18 and over up to a certain age.
That's correct. And that's why
How does that help you out? I mean, if a 23-year-old can get that treatment, they're obviously not a juvenile.
That's correct. But under the definition provided by 2K 2.1, which is where this enhancement originated, if a person is convicted and they're 18 or older, by definition in the guidelines, those convictions count. So I wouldn't be arguing about those here because, like I said, this is a very narrow slice of cases that would only involve a Youthful Offender Act conviction that occurred when the defendant was under 18 years.
So you're saying that even though a sentence for a 23-year-old, to use Judge Agee's example, has all these hallmarks of rehabilitative aspects to them, you would characterize that, it sounds like, as a juvenile sentence, but the defendant doesn't get the benefit of it because he or she is over 18 or over.
Correct. If Mr. Sitton was 23 years old and had a Youthful Offender Act conviction, even if he was sentenced under one of the youthful offender provisions rather than as an adult, this conviction would count for the enhancement because the definition in the guidelines in 2K2.1, the definition of felony conviction is defined as if the person was 18 or older when they committed the offense, it's an adult conviction. It's a felony conviction.
Well, you use that term in your brief, and it may be right. I'm trying to figure all this out. You refer to a Youthful Offender Act conviction. And that seems like a description that assumes the answer, perhaps. And I'm not suggesting you're being disingenuous, but I mean, without doubt, that there can be defendants who are youthful offenders. I mean, they're categorized that by their age. But isn't the Youthful Offender Act primarily a sentencing alternative? So you're youthful, you're convicted of a crime, and then based on that age, the Youthful Offender Act provides sentencing alternatives. It seems to me that's how I read it in terms of how it's operate in practice.
I think that's a fair interpretation, but that's one of the reasons I cited to the Gay case, because that is the case where they refer to the expungement statute. And I believe the title of that is a youthful offender conviction. Okay. And they referred to it as conviction. And it's something that it was very difficult to read through these state cases and try to find out how it was characterized. But I believe with that case and with some of the other state cases that I cited, it does seem to say that, and I don't disagree that it seems kind of strange, but there are a lot of things in South Carolina state law that might not make sense in the federal world. But the Youthful Offender Act, that's why it's a hybrid. I'm not up here arguing that it's a strictly juvenile adjudication. What I'm saying is it's somewhere in between, and that based on the guideline definition, if the person is 18 years or older, the guideline definition covers that. It would be a predicate offense. If it's only these ones that are kind of caught in between where the person is under 18 and is convicted as a youthful offender and then can be sentenced either as an adult or under the Youthful Offender Act. They're a hybrid, so it doesn't meet that example given in the guideline definition of felony conviction and adult conviction that the person must be expressly proceeded against as an adult. That's the distinction that I drew from the case law, and this court in English, albeit an older case and an unpublished case, it cited to the Kraft versus State case in South Carolina and explicitly recognized that YOA convictions are neither juvenile nor adult. And I believe that's the exact language from English. So it was referred to as a conviction there as well.
Could I ask you to address one point?
Sure.
As I understand how the enhancement works, there's kind of a two-pronged inquiry. One is whether there is an adult conviction, and that's kind of what we've been talking about. And then it seems like there's an additional question of it, whether it's adult conviction for which criminal history points are awarded under Chapter 4. And you seem to suggest, yeah, that is a requirement and focus on, part of that. But is it not permissible that the criminal history points can also be awarded under, 4A1(2)D and 2D2? You focus on D1, which is the year and the month, but there's also criminal history points that can be awarded under D2. And so if we do have an adult conviction and we're looking to see whether it's one for which criminal history points can be awarded, I understand that this is less than a year and a month, but why wouldn't D2 A or B apply? And doesn't it look like in the PSR they applied D2A by virtue of awarding 2 points?
No, I apologize for the original briefing. That was very confusing when I went back and read it. So I'm happy to answer any questions about that. It is true that I got the criminal history points, 2 criminal history points under, I believe it is under 4A 1.2 D2A. So that can be an adult or a juvenile adjudication. And it was because that offense, the YOA offense occurred within 5 years of him.
You don't have a quarrel with that. Your issue is on the first point of whether it's adult conviction in the first place.
That's correct, because I'm under plain error review because this wasn't raised below. And while I did cite the Glover case, it's out of the 11th Circuit, and they did apply this sentencing, because if you look at all the the career offender guidelines, chapter 4, and look at how the criminal history points have to count, and they refer to it as this, there's been a demarcation of a year and a month sentence being an adult sentence when it relates to the career offender and the criminal history points. The Glover case out of the 11th Circuit that I cited did cite to the criminal history point guideline for purposes of applying the 2K 2.1, but I would say that is unclear in this circuit, and it's unclear from my reading, my multiple readings of the guidelines to try to figure that out. So I thought, well, I'll just go with the 2K 2.1, the explicit language and the cases related to that. So
Thank you, Ms. Albro. You've got some time left on rebuttal.
Thank you.
Ms. Flynn?
Thank you, Your Honor. May it please the court. My name is Catherine Hollingsworth Flynn, and I represent Appellee United States of America in this matter. Your Honors, neither South Carolina's Youthful Offender Act nor case law clearly preclude Mr. Sitton's 2012 South Carolina conviction for assault and battery first degree from being an adult conviction. Thus, there was no plain error in the district court's guidelines calculation in Mr. Sitton's case. Further, after considering the pre-sentence report, the guidelines implicated in that report, and the arguments of the parties, the district court clearly indicated it would have imposed the same sentence even had it calculated the guidelines differently. And under the totality of the circumstances in this case, that sentence would have been reasonable. Thus, even assuming the district court plainly erred in calculating the guidelines applicable to
Well,
Mr.
if we
Sitton.
agree with you that there was an adult conviction, we don't get into any of that.
That's correct, Your Honor. If there is an adult conviction, or even if it is unclear whether it is an adult or a juvenile conviction, then it cannot be plain error for the district court to have calculated the guidelines as it did.
So is it case determinative here that Mr. Sitton's prior conviction was in the general sessions court as opposed to juvenile court?
Your Honor, I think this court has clearly indicated in English that South Carolina's YOA does not define convictions as either adult or juvenile convictions. But the case law indicates that that is a fact-specific determination. And drawing from this court in English, from the 11th Circuit opinion, which is cited in English, and from the Mason case from this court, it appears that the relevant facts specific to that determination are locus of prosecution. So that is that transfer from family court, which would normally have jurisdiction, to general sessions where Mr. Sitton was in fact prosecuted for that assault and battery first degree. It is the type of sentence imposed. The South Carolina YOA allows for a variety of types of sentencing options. This court has said that the South Carolina YOA sets forth a discretionary sentencing alternative. And those sentencing alternatives run from more supervisory type sentences to actual incarcerative type sentences.
So, but the English case has three facts. First of all, the English case is an unpublished, non-binding case. Or do you think we should follow that, or should we? Because that case talks about two factors, two of which look at the sentence. And it looks like the inquiry under the guidelines is the conviction, not the sentence. So I wonder if that makes sense. And what do you think? Do you think we should do as Judge Agee said and place almost dispositive, if not heavy weight on the court in which the conviction takes place? Or do you think we ought to look at what the 11th Circuit said should be looked at, or what an unpublished case should be says we should look at?
Your Honor, I think that the guideline 2K2.1 directs us to look at the type of conviction. And application note 1 to that guideline says that the conviction only counts as a predicate conviction if it is an adult conviction, which means if it is classified as such under the laws of the jurisdiction where convicted.
Okay, so what's your best South Carolina case in support of your position? So it seems like we need to look to South Carolina law.
And Your Honor, I'll be clear, the statute is not clear as to whether convictions under the South Carolina YOA are adult or juvenile convictions. But I think this court, in taking this issue up in English, indicated that that is a fact-specific determination. It's cited to the 11th Circuit in opinion. So
you don't really have any South Carolina?
Your Honor, I think, my apologies, I think that appellants' cases are concerned with sentences. And I think the type of sentence is one of the facts that plays into the determination of whether a YOA conviction is an adult conviction. But the guideline directs us to look at convictions, not sentences. And this court in Mason explicitly distinguished between a conviction and a sentence. A conviction is not a sentence is not a conviction.
So under, and I'm asking because I don't know, as follows Judge Thacker's question, is a conviction as opposed to the sentence, and as opposed to a juvenile disposition, is that a factor under South Carolina law for sentencing enhancements or some other factor? I mean, is there a reason why South Carolina courts would have a need to define what an adult conviction is?
I don't know the answer to that in terms of what South Carolina courts have a need to define whether a YOA sentence is an adult or juvenile conviction.
Maybe to determine whether it qualifies under the two strikes law in South Carolina.
And I will be forthright, I'm not familiar with the two strikes law in South Carolina and how this would play into that. But I do think that the guideline that is at issue before this court, the 2K2.1, directs us to look at convictions. And I think the case law is applied through English, through Mason, and through the 11th Circuit opinion indicates that there is a fact-specific determination as to whether a YOA conviction is an adult conviction. Those facts are locus of prosecution, as we've talked about. The family court in South Carolina typically has jurisdiction of juvenile criminal offenders. For those offenders to end up in general sessions court requires a transfer of jurisdiction. The other factors that are relevant under the case law are type of sentence and actual time served. Here, Mr. Sitton was 16 when he committed the underlying assault and battery, but he was prosecuted in general sessions court, which of course requires that transfer. He was sentenced to an actual incarcerative type sentence of 385 days. And I would turn the court to Joint Appendix 156, which is the sentencing sheet from that conviction. It does state that Mr. Sitton was 17 on the day he was sentenced in general sessions state court. But in fact, it also lists his date of birth. He had passed his 18th birthday at that point. So he was sentenced after the age of 18 in the typically adult court in South Carolina. He was sentenced to an actual custodial sentence of 1 year and 25 days, 1 year and 20 days. And Your Honors, Mr. Sitton's cases from South Carolina focus on sentences. This part of the guidelines directs us to look at convictions. They are not the same thing. Furthermore, we've talked about application note 1 to section 2K 2.1, which tells us that we have to look at whether the state classifies this as an adult conviction. Application note 10 to the same guideline indicates that only felony convictions that receive criminal history points under 4A 1.1, A, B, or C count as predicate convictions. Moving from there to 4A 1.1, application note 1 directs us then to 4A 1.2D. And there is a distinction in 4A 1.1D, 4A 1.2D, excuse me, Your Honor, between 3-point criminal history of offenses, which are explicitly adult or juvenile sentences. And now we're back to the sentence conviction distinction that occur within the relevant look back period. So, Your Honor, I would say as to this piece that there is simply no binding precedent that establishes that Mr. Sitton's assault and battery conviction was not an adult conviction. So any error here by the district court in enhancing Mr. Sitton's guidelines pursuant to his previous assault and battery conviction was not plain. Your Honor, moving on, even assuming there was a plain error in the calculation of these guidelines, that error was harmless because both prongs of the assumed error harmlessness test under Savion-Matute as incorporated at the third element of plain error were met in this case.
Does that argument depend on the district court's language that it would have imposed the same sentence anyway?
I think that is part of what comes in to this analysis.
Does it concern you at all that Mr. Sitton argues that appears to be just kind of boilerplate language without any explanation, and that it's issued pretty regularly, by the particular district court and others? Are we supposed to just accept that without any further explanation or fair consideration?
Your Honor, I think that the argument that this is boilerplate language fails for at least two reasons. First, we simply have no way of knowing what the district court says in every or almost every sentencing because we have a selection effect problem.
Was able to list a fair number of cases in which this boilerplate language was used.
Certainly, but we cannot, Your Honor, take from that what the court would say in every sentencing.
That's sort of the problem. Because the court didn't have an opportunity to specifically address or didn't take the opportunity to specifically address the issue here.
And Your Honor, I think the court did specifically address the issues here. First of all, comparing the court, let me back up one step. The court specifically said it would have imposed the same sentence, although that's not a required statement to meet the first prong of Savion-Matute. It's also not a meaningless statement. Under Molina-Martinez, where the record is silent as to what the court might have done had it calculated the guidelines differently, an incorrect guidelines range is usually prejudicial, but the government can point to all parts of the record to counter a showing of prejudice. And so we do not read that single sentence of, if I've calculated the guidelines incorrectly, I would have imposed the same sentence in isolation from the rest of the record.
But right around that time, the district court is talking about how the defendant has gotten the message and things that are favorable. You would think an alternative variant upward in the event of a lower guideline range would be accompanied by, more critical language, if you will, rather than complimentary language.
Well, I think this district court
could, in this record, issue language that would be sufficient. The trouble is at the point where that language is issued, it's not tied back to the things you're articulating. And, maybe, there's some law that would allow us to look at the record as a whole and do that. I get that. But Yeah, the concern, quite frankly, is it's just language without any connection to other parts of the record. So we're trying to figure out if that's what the district court meant or not. And that's not your issue. I realize that, but that's the concern of language without connection to the record.
Well, and I think the language here, Your Honor, does clearly tie to the record. Again, it ties to the PSR, to the guidelines issues at play in this case. It ties to the arguments of the party. And having listened to those arguments, having considered the PSR, having considered the guidelines at play, this court made an individualized, specific determination tied to those as to why this was the appropriate sentence in this case. Furthermore, when we compare the court statements at sentencing, and here I'm going to JA 125, 126, with probation's form of recommended sentence at volume 3 of the joint appendix at 2, they are in fact not the same. The court, again, ties to criminal history, dangerousness of conduct, rehabilitation and mitigation, which were those very factors.
For a within guidelines sentence, right?
It does that in the first statement for a within guidelines sentence.
This was a within guidelines sentence, correct? Is correct. This would be converted then to an upward variance above the guidelines. And you're saying the court would not need to say anything more about an upward variance than the boilerplate language that was used.
Your Honor, again, I do not think that this is boilerplate language.
Okay,
but
assuming I do. Okay, then
Yes, Your
what?
Honor.
Then there's nothing, that's still good enough?
I think the totality of the record shows that the district court explicitly considered the factors that are relevant under 35. Secondly, as to the second prong of Savio Matute, if this were in fact a 7-month variance from the top of the otherwise applicable guidelines range, that would have been a reasonable sentence under the totality of the circumstances in this case. Mr. Sitton was on probation at the time he possessed the firearm in this case. He possessed a high-capacity firearm, allegedly in connection with drug trafficking. Law enforcement was called to the scene because there was a report that somebody was trafficking drugs. Mr. Sitton matched the description of that individual. Mr. Sitton pled guilty to being a felon in possession in federal court. He bonded out. Within 2 weeks, 2.5 weeks, he used controlled substances. He cut his ankle monitor and he fled. He was at large for more than a year. When he was ultimately apprehended and brought back before the federal court, it was not on bond warrant violations. He was allegedly committing new criminal conduct in the form of failure to stop for a blue light and hindering an officer. Under those facts, that totality of the circumstances, a 7-month variance upward from what would have been the otherwise applicable 51 to 63-month guidelines to reflect the pattern of continued criminality, flouting of both the state and federal courts rules, and flight from prosecution would have been reasonable. Your Honors, because there was no plain error in enhancing Mr. Sitton's sentence based on his prior conviction for South Carolina assault and battery first, or because any such error was harmless, this court should affirm the district court.
I can address the youthful offender under the act doesn't negate the fact that the case law refers to it, the statute itself refers to it as a youthful offender conviction. And contrary to what the government says, that if it's unclear what the offense is, whether it's adult or juvenile, then it doesn't meet plain error. That's the wrong standard, because the guideline requires it to be expressly proceeded against as an adult. And the case law makes it a hybrid type conviction. So it is not under South Carolina law. The Youthful Offender Act is not something that where the defendant is expressly proceeded against as an adult. And the Youthful Offender Act is in Title 24, Chapter 29 of the Code. And at 24-1950 of the South Carolina Code, that's where the alternatives for sentencing are given. It says, if in the event of a conviction of a youthful offender, in the Gay case, where the expungement statute is cited, following a first offense conviction as a youthful offender. He's not adjudicated as a juvenile, but he's also not convicted as an adult. And that is why we submit that the definitions provided in the guidelines, when you compare them to how the state law treats the Youthful Offender Act, it is not, the conviction is called a youthful offender conviction.
But the Youthful Offender Act, whether it's a conviction or a sentence or a hybrid or whatever it is, wasn't determinative under English. And it wasn't determinative but in the 11th Circuit, both of those were Youthful Offender Act convictions. So again, I made the point those aren't necessarily binding, and that's true on what I'm saying now. But to the extent they're persuasive, they make the point that whether it's a Youthful Offender Act isn't a showstopper for adult conviction either. And the court you're in is a factor, and that would be General Sessions. Is any sentence imposed? And here there is a sentence. It's less than a year and a month, as you point out, but at least it's more than there was in English. So, I mean, do you agree that the Youthful Offender Act is just a factor and not determinative? Or is it your position that it's determinative?
It's our position that because of the statute itself and the cases interpreting it, that it is not expressly an adult conviction, so that it is determinative. But and there are two ways that you can go. You can take that bright line rule that these 16, 17 and younger people who are convicted under the Youthful Offender Act don't expressly have an adult conviction. If you adopt the government's position that it's case by case, I think then you go back to.
So which is your position though? Are you saying if you're under 18 in South Carolina that there's no adult convictions?
That if you're convicted under the Youthful Offender Act, that is not an adult conviction.
Well,
that's the position.
The youthful offender. I thought we established that that's a sentencing mechanism.
Well, that's why I pointed to the language in the actual youthful offender statute where they refer to it as a conviction, and the Gay case where it's referred to as a conviction, and the expungement statute cited in the Gay case also refers to it as a youthful offender conviction, where it's this kind of hybrid.
Make sure I understand your argument. I mean, is it your position that if you're 17 years old, convicted in the General Sessions Court, that cannot be an adult conviction?
That is, if you draw a bright line rule, that would be my position.
What's your position?
Well, that was our position, and that is what I argued. But if you take the government's position where they're arguing it would be case by case, then you get into factors like what kind of sentence was given. Is it an indeterminate sentence? Is it one for rehabilitation and typical juvenile type rehabilitation matters? And then you might want to look at the same language for felony conviction is used in career offender. And then you get back to the year and a month sentence, which Mr. Sitton didn't receive. And I see I'm almost out of time, but I didn't address harmless error at all. So I would just say that if the first prong isn't satisfied because you find this is a boilerplate statement that can't be relied on because no reasons were given, then you don't get to the second prong about totality of the circumstances under Savanamitude. And I would just point out, do you mind if I do one case citation? There was a case that came out today. I believe Judge Thacker was on the panel, actually, U.S. versus Reeves, number 21-4397. It was a supervised release case. I believe it was in the same court as here. And on page 4 of the slip opinion, it says that meaningful appellate review could not be done based on this alternate variant sentence statement because reasons were not given. So thank you for your time.
Our normal court practice is to come down and greet counsel in person. That's a victim of COVID. So we'll simply thank counsel for their arguments today, and I'll ask the clerk if they would adjourn court for the day.
This honorable court stands adjourned. God save the United States and this honorable court.